I'm George Whipple, one-on-one with Alex Barnard. So talk to me, you got a quarter of a century of experience in litigation and in investigating whistleblower issues. What's the number one thing you think about when you first hear whistleblower?
Well, George, I think it's one of the most difficult things that you face inside a big bank or a big company. Someone internal who's raising an issue saying there's something that's been handled the wrong way, in particular if they're a subject matter expert in that space. And we've seen lately some of these situations where you have someone whose job it is to make sure that things don't go wrong, like a compliance officer or a risk officer, or heaven forbid, a lawyer that ends up being the whistleblower. And it becomes a very significant issue. Any complaints from employees in an ongoing employment relationship are difficult. But when you have that subject matter expert, it's even more so.
Talk to me a little bit about that. I mean, if it's your job as a lawyer or compliance officer to uncover wrongdoing or to prevent wrongdoing, how can you become a whistleblower when that's your job?
It's a very good point. In order to blow the whistle, you presumably are pointing to something new that's not already known. So if I hire you to address a compliance issue and you point to that issue, well, you're not identifying anything new. That's not whistleblowing.
That sounds like doing your job to me.
It is. The question in some of these cases is, number one, will court recognize that there is whistleblowing within the area that you've been assigned to? And if so, how do you draw the line between things that they're doing that are part of their job and a complaint that things are being handled in an unethical or fraudulent or bad manner? And that's where they're trying to point to. They're not saying they pointed out a problem, but their boss is trying to swipe it under the rug. And it's that secondary piece of misconduct that they're trying to say is a whistleblowing situation.
Well, that sounds like a very thorny issue, complex issue inside of an organization, because you've got either a lawyer or a compliance officer that's now acting as a whistleblower. How do you thread that needle, Alex?
I think the best thing to do, George, is what we've always done, which is to follow the normal path. You investigate every claim as if it has total merit, even if you think it does not. Determine whether what someone is pointing to is really just them doing their job, like a lawyer advising on risks in a transaction. And find out, was there any wrongdoing? Was there anything in which the person was not treated fairly? And have a report so you can show that this was done. And you can talk to the person about it as well to let them know that. The most difficult thing, George, it's what we always talk about. It's retaliation. It's a claim that maybe the basis of it isn't there. It's not a real claim, but then someone retaliates in some way. And that's I think, the trickiest area in the space by far.
So retaliation is absolutely prohibited when there's a good faith claim, even if it's wrong.
That's exactly right, George.
But what if somebody brings a claim in bad faith to try and enhance their position within an organization, to extract a severance, or whatever their motivation would be, a bad faith claim? Can you take action if you've learned that the employee has raised a claim in bad faith?
That's the very difficult situation. I think the person that's most directly involved, say the person's boss, whoever the finger might be pointed at in this circumstance, probably takes that a little bit seriously and personally. And if they feel that it's false, they may think it's bad faith, and that's pretty common, actually. It's hard to prove bad faith, and I think ultimately if you can prove it, you can take some action, but it's an area to tread very carefully on, because you don't want to take a claim that's false, good faith or bad faith, and then imbue it with life with a new claim through something that you did. And then what's the something that you did? What does that mean? And it can mean almost anything. It could mean freezing someone out of a meeting. It could mean not talking to the person, not giving them client opportunities, whatever the case might be, that they can point to an employment-related action that's negative, that's based on their protected disclosure. So it's one of the hardest things, I think, to tell people. They have to basically act like the complaint was never made. Put it out of your head and act like that person is the same person as before, because they are. I think people can do it, but they need to hear that bluntly. That's the job, is to put it out of your head.
Well, thanks for being here, Alex, and thank you very much for watching. I'm George Whipple.